talking about the mediation of employment law cases today. Mediation is a very common process that takes place, particularly with employment law cases. When you file a complaint with the EEOC, many times, not always, but many times the EEOC will offer the opportunity to do mediation to try to resolve the employment complaint. And when you go to court, many times the judges will require that a mediation take place in your case before they will let you go to trial. And many times the judges will require it early on or early in the case. So what is the procedure for mediation? How does it work? Well, mediation involves a neutral third party called a mediator. And typically the way the mediation would work is the parties from both sides come to the mediator's office or to some other neutral location with the employee on one side of the table and the employer on the other side of the table with their respective lawyers. And the mediator begins the process by making an opening statement explaining how mediation works, etc., etc. And then the mediator will ask the lawyer for the employee to make an opening statement, typically explaining what the case is about, what the damages are, what they're looking for in the case. And then the mediator will look to the other side, to the employer, to give their explanation about what the case is about. This is a joint session where everybody is typically together. Once the two lawyers have spoken, the mediator will often ask the actual employee and the actual employer or the employer's representative if they want to make a statement. Many times they don't, but occasionally they will make statements, and there's nothing wrong with that. Once this joint session and the opening statements are made, the mediator will typically take one of the parties, their lawyer and the client, to another room. And the mediator will go back and forth between the rooms throughout the day to try to make a resolution or a settlement of the case by getting the parties to negotiate. Sometimes this can take all day, it can go into the night. Other times it may just take an hour or two. It really depends on the position of the parties and their interest in really trying to resolve the case. But at the end of the day, if the case is resolved, then whatever complaint has been filed with the court is dismissed. And if it's not resolved, then the case continues either with the EEOC or with the court. Ultimately, the employee is the one who decides if they're going to accept a settlement. So nobody forces a settlement onto the employee. What is the role of the mediator in this process? Well, the mediator is there to try to get the parties to see both sides. The employer feels very strongly about their case, typically. The employee obviously feels strongly about their case. And the mediator tries to poke holes in both cases and tries to get the parties to see the other side and to see some of the pitfalls or possible pitfalls of their case, and then tries to get them to make offers back and forth to get the case settled. So this is the process of mediation. It can take place at any time. The parties can typically pick their mediator if they're able to agree, and if not, many times the judge will appoint the mediator.